Welcome to the third video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, these YouTube videos cover all of the substantive content of the book. If you watch all 9 videos and internalize the concepts explained in those videos, you will have an expert knowledge of interrogation law without spending anything but your time. If you have not started with the first video, I encourage you to do so. It discusses evidentiary and constitutional provisions that will be helpful in understanding the more nuts and bolt content of this and other videos in the series. It also tells you about my background and describes some of the supplemental content that only appears in the book. The book is bargain priced and for most folks easier to use as a reference tool than the YouTube videos. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. If you watch all 9 videos, you are going to learn a lot about interrogation law. But in any event, I'll feel rewarded in being able to pass this information along to a wider audience. If officers are able to use these techniques to make cases and take criminals off the streets, I'm a happy guy whether or not I make a buck off of it. So on to today's lesson. This is video 3, which covers non-Miranda Fifth Amendment self-incrimination issues. The self-incrimination clause of the Fifth Amendment of the United States Constitution provides that no person shall be compelled in any criminal case to be a witness against himself. The plain language of this provision suggests that it ought to be limited to compelled testimony in court, and indeed much self-incrimination law addresses that. But the Fifth Amendment right against self-incrimination has also been applied outside the courtroom. The most litigated example of this is the Miranda Rule, which regulates custodial interrogation by law enforcement officers. The Miranda Rule will be examined separately in the next video. This video focuses on non-Miranda self-incrimination issues. As a general rule, Fifth Amendment claims must be raised by the holder of the privilege or they are waived. This is called the raise or waive rule. Put another way, the privilege is not self-executing. For example, witnesses at trial are sometimes asked questions that, if answered, would elicit statements that would incriminate the witness. If such witnesses go ahead and answer the questions, they have waived the privilege for their direct testimony and for cross-examination. The answers to those questions may be used against them in future proceedings. To exercise the privilege in that setting, witnesses must assert the privilege, that is, take the fifth, before answering any questions about the subject. There are a number of exceptions to this rule. It does not apply to Miranda, which we discussed in video 4, and in Garrity, which is discussed later in this video, interrogations. Generally speaking, it does not apply where failure to assert the privilege is itself compelled. In other words, where it can be shown that asserting the privilege would be punished. This is called the penalty exception and comes up in cases where the prosecution offers evidence of a statement made by a prisoner, probationer, or parolee as part of a treatment or rehabilitation program, or offers evidence of a defendant's non-custodial silence. We'll talk about all of this later in this video. In some cases, the Fifth Amendment privilege can be defeated by a grant of immunity. These grants can be powerful investigative tools, often used to penetrate criminal organizations. Formal or informal grants of immunity are typically handled by prosecutors, not investigators. Nevertheless, investigators should know the basic terminology and have some sense of the problems created by grants of derivative use immunity. Here's how immunity works. Prosecutors may compel a suspect to talk, typically before a grand jury, by offering immunity. The subject may still refuse to talk, but a person granted immunity who still refuses to talk can be jailed for contempt. More often, the suspect is represented by counsel and anxious to cooperate in exchange for favorable treatment on potential charges, and the exchange of testimony for immunity is part of a negotiated plea. There are 2 types of immunity, transactional and use immunity. Transactional immunity is complete immunity for any crimes mentioned by the subject and is rarely granted. Use immunity prevents the prosecution from using the compelled statements against the subject, but preserves the option of prosecuting the subject with other independently obtained evidence. In the most common scenario, a junior member of a criminal organization provides information about other members of the organization in exchange for recognition at sentencing of his or her cooperation. Use immunity allows such subjects to speak freely about crimes they have and have not been charged with the promise that what they say won't be used against them. Unfortunately, a grant of use immunity is also a grant of derivative use immunity. That means that not just the subject's statements, but other evidence discovered because of the compelled statements cannot be used to prosecute the suspect. Even worse, derivative use immunity can also include the non-evidentiary use of the statements for trial preparation. This greatly complicates any subsequent prosecution of the person receiving immunity. A grant of use immunity may require the creation of a taint or filter team to insulate prosecutors, investigators, and witnesses from defense claims that they were assisted in some way by the compelled statements. Courts then hold pretrial hearings, called Custodial hearings, to ensure that the prosecution is untainted. All of this is exceedingly time-consuming, and subsequent prosecutions of individuals who have received use immunity are difficult and rare. There's a famous example of this. Back in the 1980s, a Senate committee wanted to question Oliver North, a Reagan administration official, about brokering arms sales to Iran. North was also the target of a special prosecutor's criminal investigation and would not testify unless he received use immunity. The special prosecutor begged the senators not to grant him use immunity, but they did so anyway. The hearings ended up being broadcast on national television, and prosecution witnesses who were not under the control of the prosecution watched the hearings and reviewed the testimony with their attorneys as part of their trial preparation. This was non-evidentiary use of compelled testimony that spoiled North's later convictions. Prosecutors avoid derivative use immunity problems by conditioning plea discussions or offers of immunity on a defendant's agreement to a proffer session, sometimes called a Queen for a Day session. In a proffer session, the subject gives a complete account of his or her knowledge and involvement in criminal activity under investigation. Prosecutors want to know what the target is able and willing to testify to before entering into a cooperation agreement. Competent prosecutors usually control the ground rules for these discussions by requiring that the targets sign a proffer agreement that, 1, provides enough immunity protection to make the targets feel free to fully disclose their complete criminal conduct, 2, makes the statements admissible in court if the target later lies in court after a breakdown of negotiations, 3, avoids any grant of derivative use immunity, and 4, lays out in detail the consequences of a later breach of the agreement. Alternatively, the terms of a plea bargain are often reduced to a document that includes a statement of facts of the crimes that are expressly agreed to by the defendant. Now, Federal Evidence Rule 410 and similarly worded state provisions provide that statements made during plea discussions with a prosecutor that don't result in a guilty plea or result in the withdrawal of a guilty plea are inadmissible. This protection is waivable, however, and competent prosecutors will put a tightly written waiver language into the original proffer or plea bargain agreement that renders Rule 410 or its state equivalent a nullity. Law enforcement officers often wish to examine the contents of computers and cell phones. Sometimes this is done with the owner's consent. In other cases, a search warrant or court order may be required. But these searches are frustrated where the owners of the devices have encrypted the contents and refused to disclose the necessary passcodes, claiming a Fifth Amendment privilege. This claim of privilege may nevertheless be overcome if the government satisfies the requirements of something called the Foregone conclusion doctrine. This doctrine predates electronic devices and was developed in cases seeking paper records from sole proprietors. Documents held by corporations are not protected by the Fifth Amendment, so corporate custodians may not assert Fifth Amendment privileges on behalf of corporations. But a sole proprietor can argue that the act of producing documents is incriminating because it affirms the proprietor's belief that the documents exist, his or her control of and possession of the documents, and that the documents are what is described in the subpoena. The act of production is therefore a testimonial statement protected by the Fifth Amendment. However, this act of production argument does not protect sole proprietors in cases where they have been given act of production use immunity, and any testimonial statement so obtained is a foregone conclusion. In ordinary computer and cell phone cases, the owner is the sole proprietor. If compelled to disclose a passcode or unlock the device, the owner necessarily affirms knowledge of the passcode, which is a testimonial statement. The government must give the suspect active production immunity and then resort to the foregone conclusion doctrine to defeat the claim of privilege. Courts are currently divided on the issue of what fact or facts are a foregone conclusion. Some courts require a showing that the suspect's knowledge of the passcode is a foregone conclusion, which is easily done in a typical case. But other courts require government foreknowledge of the identity and nature of the encrypted documents, a much harder burden. Okay, I know that's a lot to digest. Here's the simplified version. Seek voluntary compliance first. If the target is on parole and probation, check to see if consent is a condition of release. Get a waiver of Miranda rights if the target is in custody or has been formally charged. The contents of the device likely won't be suppressed by a Miranda violation, but you will lose the defendant's statement about the passcode if you don't comply with Miranda, which of course has independent evidentiary value. It connects the defendants to the files on the device. In any event, document everything you know about the contents of the device, the suspect's ownership of the device, and the suspect's knowledge of the passcode. If the suspect won't give up the password, seek assistance from your prosecutor, who can seek the appropriate court process if he or she concludes you have made a plausible foregone conclusion argument. Now, newer devices can be accessed through physical characteristics, sometimes called biometrics, such as fingerprints or facial recognition rather than passcodes. That avoids the testimonial problem. Physical characteristics are not testimonial and consequently do not implicate Fifth Amendment self-incrimination. They can be compelled by a warrant or court order without a grant of production immunity or resort to the foregone conclusion doctrine. Think of it this way. A passcode is like the combination to a safe. It is testimonial because compelling the target to reveal it uses the target statement to establish the target's knowledge of how to access the device. A physical characteristic, on the other hand, is more like the key to a safe. It is not testimonial because it doesn't require a target statement. If seeking to compel a scan of fingerprints, make sure that you specify all fingers and the thumbs in the application for the warrant or the order. If you leave the choice up to the target, the choice of the correct finger would be a testimonial act, just a needless complication that you don't need. The Garrity Rule, derived from a 1967 case, Supreme Court case, Garrity versus New Jersey, automatically accords derivative use immunity to public employees who make statements with the objectively reasonable belief that they will be fired or disciplined if they refuse to answer questions. As discussed earlier in this video, derivative use immunity means suppression of the statement and any statement discovered as a result of the statement. So successful prosecutions of suspects who have Garrity immunity are difficult and rare. Interrogators can avoid giving Garrity immunity by giving Garrity warnings before the interview starts. These are standardized forms that advise employees that they have a right to remain silent, that anything they say may be used against them in subsequent civil or criminal proceedings, but that they won't be fired or disciplined for asserting their right against self-incrimination. The downside of this is that they may happily accept the option of asserting the right against self-incrimination and won't talk to you. There is another approach. The law permits the termination of employees who refuse to answer questions that specifically, directly, and narrowly relate to the performance of their official duties, so long as they are accorded use immunity for the statements. These employees may be given Kalkines warnings. Suspects are advised that they have a duty to answer specific questions about their official duties, that they can be disciplined or fired for refusing to answer, that the answers may be used against them in civil and administrative proceedings, but they will have use immunity for the answers in criminal proceedings. So use Garrity warnings to avoid derivative use immunity problems, and Kalkines warnings to compel statements if you and the prosecutor are all right with giving derivative use immunity. Where derivative use immunity is purposely or inadvertently been granted, be aware that interviews may go back and obtain a waiver of the immunity previously granted. This is called post hoc waiver. Treatment or rehabilitation programs are sometimes a condition of parole or probation, are offered as prison programs granting privileges and early release. Treatment or rehabilitation programs for sex offenders, for example, typically require that the offender admit all of their prior sex crimes. This is sometimes called a sexual history, including crimes that the government may not know about. These statements may be covered by a psychotherapist privilege, but sometimes the involved social worker or therapist goes ahead and tells a probation or probation officer about this statement, and these people are not bound by the privilege, so they can go back and confront the offender and obtain confirmation of the statements. The raise or waive requirement described earlier in this video usually applies in these settings. The self-incrimination privilege is not self-executing, and the statements are admissible if the suspect does not assert the privilege and is not in custody. Defendants will argue that they did not assert the privilege because doing so would have resulted in a revocation of the defendant's status. That is, the penalty exception we talked about earlier applies. For example, probationers would feel compelled to not raise the self-incrimination privilege if they believed that the assertion itself would result in a revocation of probation. But courts have tended to reject this claim unless the threat of revocation was nearly certain. Federal Evidence Rule 801 D2B and parallel state evidence rules authorize the admission of adoptive admissions, sometimes called admissions by silence. A statement is adopted where it is made in the person's presence, the person understands the statement, and the person has the opportunity to deny the statement but does not do so. When offered against criminal defendants, attorneys may argue that the defendant's silence is insolubly ambiguous and unfairly prejudicial under the Rule 403 balancing test we talked about in Video 1. Failing that, they will make constitutional arguments. The following rules apply. Evidence of a defendant's silence after being advised of the right to remain silent, typically as part of a Miranda warning, is inadmissible. This is known as the Doyle Rule and is grounded in due process, not self-incrimination. It is simply unfair to tell people that they have a right to remain silent and then use that silence against them in court. Objections to evidence of silence based on the Fifth Amendment right against self-incrimination are properly overruled if the silence is used in cross-examination of a defendant. Defendants effectively waive the Fifth Amendment when they testify. This includes custodial silence as long as it occurs before Miranda warnings. Defendants do not waive the Doyle rule by testifying because it is a due process rule, not a self-incrimination rule. A defendant's out-of-court silence may be admitted in the government's case in chief, whether or not the defendant testifies, if the defendant was not in custody at the time of the silence, was not told that he or she had a right to remain silent, i.e. the Doyle rule wasn't triggered, and did not invoke the Fifth Amendment. This is another example of the raise or waive rule. So, you made it to the end. Thanks for that. If you have comments about the presentation or questions about some of the points I've tried to make in the video, I can be reached by email at contact@trialdex.com. This was the third video in a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. The next video covers the Miranda Rule. I hope to see you there.